We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And we're back with Scott Cosenza, Liberty Nation's Legal Affairs Editor, continuing the discussion on Trump's immunity case at the Supreme Court. Now, earlier we talked about pretty much what was presented to the court, but now I really want to dig into an article that you wrote prior to the actual delivery in court, and it was mentioned in court, and then it seemed nobody else was running this in the media until a few days later when Fox decided to highlight this. And once again, Liberty Nation was well ahead of the competition here.
Well, to be fair, Mark, I think it's important to mention, sadly, that the Supreme Court didn't mention my article about the brief.
They did not mention your article. They mentioned the brief that you talked about.
They mentioned the brief itself, yes.
So it's only a matter of time, Scott, before the Supreme Court starts talking about your articles. I'm almost sure of it. So in particular, there was an amicus brief filed by former Attorney General Edwin Meese and others that made the claim that Jack Smith, the special prosecutor in two of these cases against Donald Trump, doesn't have essentially the standing to be prosecuting the former president. Can you tell me how that works?
Yeah, so we should mention as a note that General Meese sits on the board of the nonprofit that publishes LibertyNation.com, although he hasn't spoken to anybody about his brief, I think, with anybody here. And he was Ronald Reagan's attorney general. And what his brief states is, so there's sort of two components to it. In many instances in appellate matters, the appellate body, whether it's the Supreme Court or a lower court that's still an appellate court, right? There are multiple levels of appellate courts. They're not permitted to include arguments or consider arguments that haven't been raised in the lower courts. So if you had a statute of limitations claim, for instance, and you didn't raise it at the trial court, you can't go in an appellate court and say, well, it was past the statute of limitations. The answer is, well, you should have raised that at trial. Sure. And then if they ruled imprudently or contrary to law on that claim, then you could bring up the claim. And this claim is a different sort, and it is appropriate, even though Donald Trump's team hasn't brought this claim up as a key part of their own arguments. Part of the Meese briefs arguing is, even still, you should consider it, because standing issues are unique in that they're appropriate for all courts to consider at all stages of litigation. If the person before you doesn't have the legal right, literally, let's talk about standing, like stand there and make the argument. Yeah. They can't do it. Why can't they do it? Well, according to Meese, Mr. Smith can't do it because only officers of the United States are permitted to make these cases. So, for instance, the president is, of course, an officer, and his constitutional officers. We're talking here about United States attorneys. These are people who are, I think there are 40, I don't know, or no, wait a second. What's
84.
The right number? Thank you. 84,
94, but there are 93 at present.
94 authorized offices, and one of them is not occupied. And those are people that are nominated by the president and confirmed by the Senate. So they are literally, you think about the way that the Republic used to work before the instantaneous communication we have now. You can't have everything go back to D.C. for decisions on these matters. So there are judicial districts throughout the United States. We all of us who live in the United States live in one of these 94 judicial districts, and each one of those is controlled by a U.S. attorney. So if you're accused of committing a crime, who signs off on a plea bargain? Who signs off on bringing someone to trial or moving ahead with an indictment? That is the U.S. attorney, not their aides and seconds. They may inform that decision, and they may say, we need to prosecute this person, but it's the U.S. attorney in whose name that prosecution is undertaken. And Jack Smith doesn't have that credential. Jack Smith was not nominated by the president and confirmed by the Senate. He was just hired by the Department of Justice. They could have hired any attorney in the world. I would guess any attorney barred in the United States and licensed to practice law there. But besides that, that seems to be the only qualification, that he has. And the argument is that, therefore, they forfeit the argument and also the prosecution itself.
is assuming that every other crime in the United States has to be signed off on for prosecution by a United States Attorney General or the president himself as an officer. This hasn't happened, so therefore that seems to make sense that they have to go back to the drawing board with this, right?
Well, that's the argument, Mark. Yes. And it was Justice Thomas, I think, that asked John Sauer, President Trump's attorney, at oral arguments about it. And Sauer said that even though they didn't plead that argument in their briefings, that they are in 100% agreement with the conclusions drawn by Meese and the arguments presented there, and that they agreed that Mr. Smith did not have standing to make these claims.
So this would be if the Supreme Court justices didn't want to essentially rule on presidential immunity
on the merits, is how we
on
would
the
say
merits,
in the legal field, right? Yeah,
this would be a very handy
sidestep. They get well, except for the fact that it would probably scuttle the prosecution. What I mean is, when you say handy, I assume there are some justices on the Supreme Court that would not like to see that result. Meaning, if they agreed with the Meese brief and said, yes, Mr. Smith can't bring this argument, now maybe the entire prosecution would be scuttled, but at the very least, it would be kicked way back down to the district court with the installation of a new prosecutor
who was officially signed up by the,
and just demolishing the prospect that could occur before the November elections, which again, we presume is the impetus behind so much of these legal affairs.
Let's just briefly cover that. So there are four big batches of indictments. There's there's two federal and two state ones. If the state ones don't take place before the November election, there's if the final prosecutions and reaching a verdict don't take place before the November election, there's a very good chance that they won't ever see the light of day again. That's about right, isn't it?
Well, I don't know that that's true, Mark. I think just because the impetus was to hobble Donald Trump's presidential aspirations, that doesn't mean that they won't. We talked earlier about prosecutors wanting to use prosecutions for their own political advancement. There may be a lot of juice left to squeeze out of that piece of fruit for any enterprising prosecutor who wants to dine on the Trump carcass, basically.
But if Donald Trump wins the election,
certainly,
then those two are dead. They're dead in the water.
The federal prosecutions will be killed twice. Number one, presumably Donald Trump will have an unsigned pardon in his pocket, ready to sign the moment that he's sworn in, and then he will sign that, and he will be ineligible for prosecution because he's pardoned. And also, he would just simply say to his attorney general, he'd fire all the leftovers from the Biden Garland AG's office, and have his attorney general file notice of non-prosecution, withdraw the prosecution from the court. So on both counts, it wouldn't proceed. Now that's for the federal. For the state, again,
the state ones,
he has no power over it. And like I said, there may be a political win there for Fani Willis if she can survive her own re-election contest.
So it could actually come down to this Supreme Court ruling that we've been talking about. That could also, though, impact the state cases as well, because presumably if the Supreme Court rules in Donald Trump's favor that there are professional presidential acts that he can take, and there are personal ones, like you can't do a hit and run and then try and hide it up.
Yeah, basically official acts and private acts are sort of one way to think about it.
But if they rule that official acts have immunity, then that would kill the Georgia probe with Fani Willis, right?
Well, it would impact it. Whether you say it would kill it, meaning we'd have to wait until the judge ruled on any motions that influenced it. I just think it's wrong to suggest like, oh well, then it's a done deal. Like they don't have to worry about that.
Of course,
it
would just make it more difficult.
I mean, they're already, to my mind, kind of using their offices in favor of political ends rather than the ends of law and order. And so to me, like would they pervert it even more to get, well, why not? They seem to already be very comfortable with maneuvering not, again, for, the benefit of their constituents or safety or anything else in their jurisdiction, but to go get Trump, so
Scott Cosenza, thanks ever so much.
thank you, Mark.
And that's all we have time for on this week's edition of Liberty Nation Radio, heard coast to coast on the Radio America Network from our flagship station in Washington, D.C. I'm your host, Mark Angelides. My thanks to our guests for this week's show, and of course to you, the listeners, for taking the time each week to tune in and join us as we examine the liberty aspects that impact your lives. Thank you for being here. We'll catch up next time. We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.